All right, my friends, here we go. The OFA had a small win today in their case against the FDA regarding tirzepatide. Going into today, Judge Mark Pittman was prepared to change this from a hearing for temporary injunction to a hearing for summary judgment. Basically, he thought he had seen enough to make a final decision in this case, but the OFA said, we don't have everything that we need. Basically, when the FDA made their announcement on December 19th that they were going to stick to their initial decision and keep tirzepatide off of the drug shortage list, they filed redacted statements that the OFA was not able to review. The FDA took out maybe critical information that the OFA needed to potentially build a case around. So when they went to court today, they made sure the judge knew that, which means that there is no summary judgment. We are moving forward with this case. There are a lot of questions that I've gotten about the timeline for the accessibility of tirzepatide, and I will say that this order kind of aligns pretty parallel with what was initially suggested by the FDA and the OFA in December. Stop talking. What does it say? Based on the findings made at the hearing, the court will not convert the impending motion for preliminary injunction into a motion for summary judgment. Further, it is ordered that 1. Plaintiffs, the OFA, shall file their motion for preliminary injunction 2 weeks after receiving the decision memorandum under the protective order entered on this same day. 2. Defendants and intervenor defendant, Eli Lilly, shall file their responses 3 weeks after the plaintiff's motion for preliminary injunction is filed. And 3. Plaintiffs shall file their reply 1 week after the defendant's responses are filed. So that's basically setting us up for the last week of February if all of the deadlines are pushed to their max. And then we should see a hearing be scheduled for the motion for a temporary injunction. Little wins. We can still access the medication, but we still have to use our voices.